Ceven Law Podcast, France, Episode 2. At the beginning of 2026, for a segment of businesses and retailers in certain commercial sectors in France, the period is marked by significant pressure. Letters from landlords under commercial lease notices of rent revision. Detailed calculation tables based on the ILC index, and sometimes still on the ICC. Documents that many immediately recognize. And almost systematically, the same question comes back. Will commercial rent continue to increase? Welcome to the Ceven Law Podcast, in France. A space where law, business, and economic reality intersect. Ceven Law is a French law firm with a national and international scope, working in tax law, business law, and immigration law. The firm is also Qualiopi certified, attesting to the quality of its legal training activities. In this podcast, drawing on our day-to-day legal advisory practice in France, we share legal analyses directly connected to the issues faced by many business owners. The topic of this episode is the following: the slowdown, or even the decline, of the ILC and ICC indices used to adjust commercial rents, and above all, their real legal consequences on commercial lease rents. In practice, a decline in an index never automatically results in a decrease in rent. That is why it is essential to clearly distinguish economic signals from the legal mechanisms applicable to commercial leases. In other words, does the decline of the ILC, the Commercial Rent Index, or of the ICC, the Construction Cost Index, actually lead to lower commercial rents, open opportunities for renegotiation, or instead reveal clearer limits on contractual freedom? Episode outline. In this episode, we will address 6 main points. 1. The legal framework governing commercial leases. 2. The type of lease concerned and its distinction from other forms of rental agreements. 3. The ICC and ILC indices, their rationale, role, and limitations. 4. The legal mechanisms allowing, or not allowing, rent adjustments. 5. An analysis of the 2025 to 2026 period, between stabilization, slowdown, and sometimes unmet expectations. 6. In 2026, particular vigilance is required, especially for commercial leases including the Construction Cost Index, ICC, and a sliding scale clause, as well as lease renewals based on market value rent determination. Let us begin. 1. The legal framework of commercial leases. Before discussing indices and percentages, it is essential to return to the legal framework governing commercial leases. In a commercial lease, rent is never a completely free figure. It is set within a specific legal framework, protective in nature, but often poorly understood. The commercial lease regime, provided for under Articles L.145-1 and following of the French Commercial Code, was not designed to favor either the landlord or the tenant. Its objective is to establish a lasting balance between the owner of the premises and the business operating its activity there. This regime is based on several fundamental pillars. A minimum duration of 9 years, a right to lease renewal, strict rules governing the determination and evolution of rent, and above all, a central principle, the statutory cap on rent increases. This legal framework explains why rent-related discussions recur regularly, sometimes in a contentious manner, but always under legal supervision. 2. What type of lease are we talking about? Not all rental agreements are commercial leases. A commercial lease applies exclusively to premises in which a business goodwill or an artisanal business is operated. For example, retail shops, restaurants, supermarkets, hair salons, beauty institutes. It is the contractual use of the premises that determines the applicable legal regime. Office leases and professional leases follow a far more contractual logic and do not benefit from the protective mechanisms of commercial lease law. Everything discussed here therefore applies exclusively to commercial leases. 3. ICC and ILC, understanding the indices. Once the correct legal regime has been identified, one question inevitably arises: how does rent actually evolve over time? The answer lies in the indices, published quarterly by INCE. Historically, two indices have been used. The ICC, the Construction Cost Index, highly volatile, closely linked to building costs. And the ILC, the Commercial Rent Index, created in 2008 to better reflect the economic reality of commercial activity. Since that reform, the ILC has become the natural reference index for commercial leases. The ICC has not been entirely removed from the legal framework, but its use is now strongly discouraged. In practice, it has led to excessive rent increases, often disconnected from actual business activity, and frequently challenged before the courts. However, understanding indices alone is not enough. One must also know when, and through which legal mechanisms, they can actually affect rent. For the three legal mechanisms for rent adjustment, one fundamental point must be recalled: a change in an index, by itself, never automatically changes rent. There are only three legal mechanisms. 1. Contractual indexation, often annual, automatic if provided for in the lease. It must apply both upward and downward. Standard formula: new rent equals current rent times new index, old index. 2. Statutory 3-year revision may be requested every 3 years, even if the lease does not mention it. It is always subject to statutory capping based on the index. 3. Lease renewal after 9 years. General rule: rent capping applies. Exception: decapping, which is strictly regulated. The burden of proof always rests with the landlord. And even when decapping is accepted, the rent increase must be spread over time, with a maximum increase of 10% per year compared to the rent paid in the previous year. 5. 2025 to 2026, decrease, increase, or slowdown. Between 2021 and 2023, the indices experienced an exceptional period of growth, often 4 to 6% per year. In 2025 to 2026, the trend is changing. The ILC stabilizes, with very small variations, close to zero. In Q3 2025, the Construction Cost Index, ICC, published by INCE, Rapid Information Number 310, the 16th of December 2025, stood at 2,056, representing a 4.06% decrease year-on-year. By comparison, in Q3 2024, the ICC was 2,143, recording a 1.73% year-on-year increase. Thus, after several years of growth, the ICC in 2025 shows a notable annual decline, while remaining upward-oriented over the medium and long term, plus 0.93% over 3 years and plus 25.14% over 9 years. This development can create potential tension between landlords and tenants for leases that apply the ICC, as it may influence discussions on rent revisions and adjustment of sliding scale clauses, which will be analyzed in more detail below. Therefore, this is not a rent decrease, but rather a clear slowdown in rent growth. Legally, rent does not automatically decrease. Economically, the logic of mechanical increases becomes harder to justify, and negotiation regains its importance. 6. Caution for commercial leases, ICC, sliding scale clauses, and market value. For all participants in the commercial leasing market, 2026 is expected to be a year requiring caution, with slowing indices and complex clauses. Understanding your rights and obligations is essential. Particular attention is required for commercial leases including the Construction Cost Index, ICC, and a sliding scale clause. Lease renewals aiming to set rent at market value. 6.1 ICC and Article L.145-39 of the French Commercial Code. Although the ICC showed an annual decline in Q3 2025, it remains upward-oriented over the medium and long term, plus 0.93% over 3 years and plus 25.14% over 9 years. This trend allows for the application of Article L.145-39 of the Commercial Code, which provides that when a lease includes a sliding scale clause, the rent may be revised as soon as the clause causes a variation exceeding 25% compared to the previous rent, whether set contractual or by court decision. The landlord has the right to request rent revision when a significant variation is observed. The tenant benefits from protection. Annual increases cannot exceed 10%, calculated year by year, which is a mandatory rule. Therefore, even during periods of slowing indices, such as 2025 to 2026, negotiation remains a key component of the contractual relationship. 6.2. The concept of market value. Many leases provide for rent determination at market value at the end of 9 years. It should be noted that market value has no independent legal existence as a rule. It is neither an automatic right for the landlord nor a mechanism provided by commercial lease law. The only legal reference is rental value, applicable only in the case of legally permitted cap removal. Cap removal requires strict conditions under Article L.145-33 of the Commercial Code. Substantial modifications to the premises. Changes in local commercial factors. Change in premises use. Valid exceptional clauses. In case of disagreement, the judge decides. Key point: even in cases of cap removal, rent increases are strictly limited to 10% per year, and no contractual clause can bypass this ceiling. References to market value cannot be used to accelerate rent revision, and vague or ambiguous clauses may be deemed null and void by a judge. Conclusion: a commercial lease is not a rigid instrument but a balanced contract designed to allow constructive dialogue over time. The landlord may request revision when significant index variations occur. The tenant enjoys legal protection and a negotiation margin, which is essential during periods of index slowdown, such as in 2025 to 2026. We hope these analyses have been helpful. You can find the Axis AU Droit podcast on audio platforms, on YouTube, or on our website, www.cevenlaw.com. This podcast is intended for informational and educational purposes only. It does not constitute personalized legal advice and does not replace an individual consultation. We look forward to seeing you again in a future episode.